Welcome back everybody to the Law of Contracts. We're continuing in this video talking about the idea of consideration, something that we introduced in the previous lesson and that we're going to spend some more time in this lesson unpacking in more detail. So as noted in the previous lesson, we took an introduction to the subject of consideration for the Law of Contracts. We examined a basic definition of consideration, and we also stated some of the early case law on the matter that really gave us something of a definition of consideration, given the fact that there is only a definition of consideration found in case law and nowhere else. And so, well, we can find it in textbooks, of course, but in terms of what consideration fundamentally means, you can really just understand consideration to be something for something else. English law does not recognize the existence of contracts that are one-sided in terms of obligations. So if I make a contract with somebody where I give them a watch, for example, and I do so without anything in return, then this would not be valid at law in England and Wales because there would be no consideration. I'd have to receive something in return for that watch in order for there to be valid consideration and therefore a valid contract. This lesson is going to explore in more detail some of the more important elements of consideration. We're going to talk about how the principle of consideration actually establishes the existence of a contractual arrangement, a contractual relationship. So, fundamentally, the whole point and the whole concept of consideration provides that fundamentally if an individual has a promise made to them to provide or to perform some kind of action, they are only able to enforce that promise in English law if they themselves have also made a promise in return. We can have examples where people have made agreements between parties where there is only a one-sided number of obligations. That's perfectly fine, but that would not be a contract in English law, and it would therefore not be enforceable under breach. So the result is that there has to be something made in return in order for that person to actually enforce the obligation onto me as part of a contract. This is really where we get the general consideration that, the general principle that consideration moves from the promisee. What does this mean? Well, according to the case of Tweedle and Atkinson from 1861, we can understand the way in which consideration is illustrated. It must be something which comes from a party to the contract, and it can't come from a third party. So it must come from the person who is making the promise. It has to be, I promise you this thing in return for something else. It could be, like I said in the previous lesson, the purchase of an item. If I were to buy a phone off somebody, I would do so by giving them money, giving them an item in return for that property. There is something exchanged there. There is an exchange of things. Now, this thing could be an item, it could be an object, or it could be a service. It could be an obligation. Someone might pay me to clean their car, and that would result in an exchange of value, fundamentally. The value in the service, the car that is being cleaned, versus the value in the money, of course, the money that they use to pay me for that particular service. This case, the case of Tweedle and Atkinson, fundamentally illustrates the fact that consideration has to come from a party to the contract. It cannot come from a third party. It was a case which involved a wedding where the fathers of both the bride and the groom had made the joint decision that they were going to each contribute a lump sum to the groom. This seemingly was intended to be a legally binding contract, and they included a clause within the contract that allowed the groom to sue for breach in the event that one party did not pay this lump sum. So it was considered that there was definitely an intention on the part of the parties to create legal relations. When the father of the bride did not pay, the groom, as a result, sued as a result of this breach. The reason why this case would ultimately fail is because it did not adhere to the principle that consideration must flow from the promisee. It must flow from the person making the claim. The groom here was a third party. The groom had not made a promise in return for the lump sum that they were going to receive. In fact, it was the groom's father who had made that promise. There was an agreement between the bride's father and the groom's father, not between the bride's father and the groom. The groom represented in this case a third party. And so the result here is that because there was this principle that consideration must flow from the person making the claim, that person cannot have been the groom, therefore the groom could not have sued the bride's father for breach of contract.